資深司法任命建議小組委員會呢，就我哋夠法定人數呢，我哋呢就要開會。我第一件事呢，我哋係選舉主席嘅，咁請大家提名。梁家傑議員。
This is Subcommittee on Proposed Senior Judicial Appointments. All right. Nominations. Mr. Dennis Kwok, are you willing to accept the nomination? Mr. Kwok, yes, Chairman. Do we have other nominations? No? Then Mr. Dennis Kwok is elected Chairman. Members, we've just received a letter from a member of the public. So can copies be distributed to members, please? So only one member of the public has written to the subcommittee. Yes. Members, any comments, please? This member of the public wants the subcommittee to convene a public hearing. My understanding is that it's not our usual practice to convene a public hearing. Now, the last meeting of the subcommittee was held on the 21st of April 2011. Ms. Margaret Ng was the chairman, and may I refer to the minutes of the meeting?
And judicial independence should be respected in considering judicial appointment, and that it was vital that the appointment process should not be politicized. LegCo's role was to act as a final gatekeeper, not to endorse judicial appointment, which was manifestly contrary to public interest. However, such power should only be exercised in exceptional circumstances. 以我所知就係呢個小組委員會當時呢就係決定唔開公證會。
So at that time, the subcommittee decided that a public hearing would not be held. The subcommittee was of the view that it should not be duplicating the work of the JORC or JOC. And so, of course, and so it's the usual practice for us to merely ask officials questions. So, members, what do you think? Ms. Emily Lau. In fact, I support the U.S. system where the Parliament can study the proposed appointments. There will be there are hearings. Now, of course, we do not have such a system in Hong Kong, so we can have meetings of the administration. We can seek detailed information about the judges from the administration. We've got this letter from a member of the public, and I think we will see whether academics in the legal field, members of the public, and lawyers would like to give us their comments. I think if all of a sudden many people express a lot of views, then we'll see what we should do. So I think this is the first step. We can meet the officials now. And then it is said that for not one of the appointees, he has been a barrister for not too long a period. So we'd like to try to get more information from the administration. And there will be a debate at a future LegCo meeting. Now, this member of the public wants us to listen to views openly and fairly before we come to a decision. Thank you. Ms. Priscilla Leung. Now, concerning the procedures for appointing judges, the system in Hong Kong is very different from that in the U.S. In some states in the U.S., elections have to be held, and the prospective appointees have to try to canvass for votes. So this member of the public is of the view that there should be a public hearing. I have reservations about this suggestion. Their system is different from ours. In some states in the U.S., judges are returned by elections. And I think in Hong Kong, judicial appointments should not be politicized. I want to say that my ward office and the ward offices of other members have received certain comments about the operation of the judiciary. That's another matter. Mr. Paul Chairman, I understand that this meeting is an open meeting. Yes. So, members of the public can witness the whole process, and if they have any comments, they can put them directly or indirectly to this council. And I think this present approach is an established approach, and I don't think we should hastily set another precedent. Now, this member of the public is not criticizing or querying the qualifications or the behavior of a certain appointee. I think he has in mind the need to reform the entire system, and I think we should not rush into such changes hastily. Mr. Martin Liu, now I have a lot of reservations concerning following the U.S. practice. This is not our practice. This is not our convention. And as Mr. Poche has pointed out, we can't see any reasons why there should be major changes to be made to the system. It's true that concerning the operation of the JOC, that may not be as transparent as some people want it to be. We can look at the system, this system, but I don't think we should change our practice or approach. This is an open meeting. Members of the public can always write to this subcommittee. I would suggest that we follow the practice adopted by the subcommittee in the past. And Ms. Margaret said in 2011 the approach the subcommittee should adopt. I think we can now try to seek information from officials and ask them questions. Mr. James Toh, yes, I thank you for having read out Ms. Margaret's remarks concerning the approach to be adopted by the subcommittee. But I think her position only represents one view adopted by a member. And I don't think that should be regarded as, or that approach should be regarded as the golden rule. This member of the public is of the view that the public should be given a chance to give their comments.
My view is, with the recommendation of JOG, I think they have gone through detailed consideration, and if there are things that the public understand, but then JOG doesn't have enough understanding in relation to background and information of the appointment, and if those are facts, or if we need to carry out investigations, or if we need to put questions to the relevant parties, then this is an open meeting. Before LegCo gives endorsement, I think the public do have the right to act as gatekeepers. But if we haven't received any information, but then if we say that we want to convene a public hearing to see whether there are all these relevant facts, then that is a bit strange. I won't do it like that. I think this Mr. Ng has paid attention to the news and the relevant reports. Perhaps he is paying attention to this meeting. If he has some information, or if other members of the public have information which is not grasped by JOG, or if there is secret discussion that no one is aware of, if they're willing to provide information for us, because this is the last gate, if appointment is made, it won't be reversible. So I, as a LegCo member, will be willing to seek more understanding of the information. It's difficult to hold a public hearing on the appointment of each and every judge. That is not what I prefer. Next, Mr. Leung Kwok Hong. Chairman, of course, we should act in accordance with actual circumstances. I think we're talking about the monitoring of the judiciary, and very often we rely on their self-discipline. In many other countries, there will be questioning, and there are people who can veto senior judges' appointment. Now there is not the system in Hong Kong. When the U.S. president appoints senior judges, well, the Congress can exercise checks and balances. To be honest, in Hong Kong, I do have doubt about the independence of the judiciary. Well, my case against Zhang Yoxing is an example. I haven't seen such a bad verdict. The judge has put forth a lot of his opinions, and he's saying that Mr. Leung Kwok Hong, as a counselor, abused the system. So I think this is a very poor verdict. It is not a problem for me to lose money. If the judge finds it important, then a trial can take place. This is in accordance with the common law practice. Now I am monitoring the president of the LegCo, and there are powers under the basic law, but then no trial has taken place. That is not reasonable. I think many judges in Hong Kong are not worth my respect. So whenever there are doubts, whenever there are questions, we should take a look. Of course, we cannot trespass powers given to us by the basic law. If we do have the power to review Mr. Fog's appointment, then I will give my support to 400%. Now, I have not received any legal training. It's just that I am often involved in lawsuits or court cases. So my view is that I would like to check with the legal advisor of LegCo to see whether we can do it. If we can't, then of course we should not do it. Otherwise, the system will have to be changed. I find a very surprising phenomenon. Mr. Patrick Chan, or Justice Patrick Chan, has been a permanent judge for a long time now. He is going to be appointed as a non-permanent judge, and Mr. Fogg is going to be appointed as a permanent judge. Yes, perhaps this is a new way of working, but then things have to be credible. Why is this arranged? So my personal opinion is, well, if Justice Ma appointed Justice Fogg, then I would like to understand why. Can we ask Justice Ma to come here to explain, or can Justice Ma give us a written submission, then we can put questions to him? I don't know which should be the right way, but my view is rather strong. Chairman, I would like you to relay my points. Ms. Emily Lau? Now, some members have to attend another meeting at 9, so we have to leave. So I guess can we fix the date of the next meeting? Sorry, I think I understand that I am asking for a jump of the agenda item. But Chairman, can you help? It doesn't matter if you want to fix the date of the next meeting at the end of this meeting, but we have to leave at 9. Otherwise, the WKCD meeting will be aborted. Now you know that meetings are taking place in all 3 meeting rooms. After listening to officials' remarks, then if we think that there is the need to have another meeting, well, definitely there is the need, because we still haven't talked to Law Society and Bar Association. Perhaps I will invite our legal advisor to explain past operations. Yes, the Secretary can also confirm later. As our Chairman said, in the past, when in the subcommittee which handled this kind of appointments, usually the administration will be invited to explain about the appointments and the procedures. And then members can ask questions, and relevant papers can be submitted. In the past, no public hearings were conducted. Relevant parties were not invited to express views. But of course, members can decide on what you would like to do. In 2011, the relevant subcommittee had a discussion of this matter. And then in the AJLS panel, there was also relevant discussion. I can share with you the points made at that time. If you refer to the background brief prepared by the Secretariat, CB bracket 4 590/1213 bracket 01. Para 13 of the paper, page 4 of the Chinese version. On the 23rd of November 2009, AJLS panel had a discussion on the procedure. At that time, members expressed views. In general, that the process of judicial appointments should not be politicized, as it would violate the fundamental principle of separation of powers. They considered that LegCo should exercise its power of endorsement prudently, and that judicial appointments should best be left to JOC, a body with legal professionals as members best equipped to consider the judicial qualities of a candidate. LegCo's power to endorse judicial appointments was substantive, in that it could act as the final gatekeeper to stop a judicial appointment which was manifestly contrary to public interest. However, such power should only be exercised in exceptional circumstances, and it should be a constitutional convention for LegCo to accept nominations made by JOC. Clark, any supplements? Not really. But among the members of JORC, there are representatives of Law Society as well as Bar Association. Okay, I think Ms. Lau's point is very straightforward. She is worried that one meeting is not enough for us to finish discussion. I understand that other members have to leave for other meetings. Then if we really need a second meeting, then, well, perhaps we should first fix a date. Is that what you want, Ms. Lau? Yes. We are trying to find time slots because things are rather tight now. I will leave some time for our clerk, and then later on, I will report to members the time slots available. Let's invite the administration representatives to come in. Ms. Lau, you want to speak first, or should the director speak? Chairman, if you allow, I would deliver some opening remarks. Good morning. On the 8th of April, the administration wrote to the chairman of the HC to notify members that according to Article 88 of the Basic Law, the CE had accepted the recommendations of JOC to appoint Mr. Justice Joseph Paul Falk as a permanent judge of the Court of Final Appeal, Mr. Justice Patrick Chan as a non-permanent Hong Kong judge of the Court of Final Appeal, and the Honorable James Spiegelman and the Honorable William Gamon as non-permanent judges from other common law jurisdictions of the Court of Final Appeal. Article 44(6) gave the CE the power to appoint judges of different levels. And Article 88 states that JOC would make recommendations, and then the CE will make appointments. And according to Cap 92 of the Hong Kong law, JOC was established to implement the functions stated in Article 88 of the Basic Law. They will make recommendations to the Chief Executive. And then in Article 90 of the Basic Law, it is said that the CE, apart from following Article 88, should also need the consent of LegCo members in appointing senior judicial officers. The administration will move motions as soon as possible to seek LegCo members' endorsement to all the senior judicial appointments. Thank you. Any supplement, Ms. Lau? No, thank you, Chairman. Mr. James Toh. Concerning Justice Fogg, I would like to get some information. Now, he has been a judge of the Court of Appeal for only a short time. So what are the factors of consideration by JOC? Are there some statistics on, for example, the number of cases handled by Justice Fogg in the Court of Appeal? and how many verdicts he has written during his term of office in the Court of Appeal. Now, let's say a person may be an excellent lawyer, but then after he becomes a judge, his judicial quality may not be the same as his performance as a lawyer. For example, his temperament during trials, or when he listens to statements made by lawyers or those unrepresented parties, are things that have to be considered. So after a judge has become a judge, I think we have to look at his performance. Has Jock taken into consideration these factors?
政務長答。
Yes, Chairman, I think the JA can answer this question. Yes, Chairman. The JOC selected the judge with the most suitable professional and judicial qualities. So the JOC acted in accordance with the provisions in the Basic Law. After detailed discussion, the JOC was of the view that Mr. Justice Joseph Paul Falk was the most suitable candidate. But then, of course, I can't disclose the deliberations of the JOC because those have to be kept confidential. So the JOC considered the judicial qualities required of a permanent judge, and came to the view that Mr. Justice Falk was outstanding and of eminent standing and reputation. Yes, I understand that the content of the discussion has to be kept confidential, but then Mr. Justice Falk has been a JA for not too long a period of time. That's a fact. So how many cases has he heard as a JA of the Court of Appeal? How many judgments have he or has he written or handed down? And did he sit at the CFI? And how many judgments did he write? How many cases did he hear? And when he was the deputy judge, then how many cases did he hear? How many judgments did he write? Or was all such information made available to the JOC? If the answer is no, can such information be made available to this subcommittee for its consideration? Yes, thank you, Chairman. The JOC is chaired by the CJ. There are two judges sitting on JOC, and there's also a barrister and a solicitor sitting on the JOC. JOC was provided with the CV of Mr. Justice Joseph Paul Falk, and of course, this subcommittee has also been given his CV. And if you want to have the judgments handed down by Mr. Justice Falk, such information is available. It's open information. In fact, judgments handed down by district court judges and above have been uploaded onto our website, so we can very easily provide such information to Mr. James To and the subcommittee. I want to know whether such information was submitted to the JOC for its consideration. You mean the judgments written by this judge? Have they been made available to JOC? Is that your question? Now, because this is a special case, he has been a JA for not too long a period of time. So is it that the members of the JOC merely said that, oh, I know him very well, or was the JOC informed of the number of cases he heard as the JA, the judgments he handed down, and so on and so forth? Was such information made available to JOC? Ms. Lau, I can only say that the information needed by JOC was presented to JOC in a suitable manner. But concerning the exact manner in which the information was presented to JOC, I don't think I can give members any information. But we have no difficulty providing members with judgments that have been handed down by Mr. Justice Falk. All right, Mr. Martin Liu, Ms. Emily Lau, Mr. Paul Chen, Ms. Sid Ho, and Mr. Leung Kwok Hong, and Ms. Priscilla Leung. So these members will ask questions in the first round. Mr. Martin Liu, now concerning the appointment of the permanent judge, I think this is a good choice. Mr. Justice Falk is very experienced. He enjoys eminent reputation. Now, because I come from the legal sector, I know him well, and those not in the legal sector may not know him too well. And then concerning Mr. Justice Spiegelman and Mr. Justice Gummo, these are also excellent choices. Mr. William Gummo, in fact, is of extremely high standing in the common law world. But then one of them is 70 years old. The other one is over 60. You want to know why they are at this age? I know this is because they were born early. But I want to know whether age is a consideration in appointing non-permanent common law judges. Mr. Justice Gummo may not want to travel by air 1 or 2 years later. So is age a consideration in appointing non-permanent common law judges? So does the JOC take into account the age of the appointees and also their health conditions? Ms. Lau, the CFA ordinance doesn't include a retirement age for non-permanent common law judges. I'm not talking about a retiring age. I'm talking about whether this is a factor that is considered by JOC. Now, when we consider the appointment of non-permanent common law judges, we consider jurisdictions like New Zealand, Australia, and the UK. New Zealand is a small common law jurisdiction, and so only retired judges from New Zealand can become non-permanent common law judges of the Hong Kong CFA. Now, in the UK, there are serving justices who are also non-permanent common law judges of the Hong Kong CFA. But then concerning non-permanent common law judges from New Zealand and Australia, they are in most cases retired justices or judges. And that's why they may be more advanced in years. But then when we do take into account the health conditions of these appointees. They are physically fit to become our non-permanent common law judges. Ms. Emily Lau. Now we can see that the appointment process lacks transparency and accountability. Now, we're not saying that we want fundamental changes to the system, but you can't just tell us every time that, oh, this has been considered and that has been considered. So can you, for example, disclose the justifications, for example, the age of the appointees, the fact that a certain judge has been a justice of appeal for a short period of time only. Now, you can't just say that JOC members are representative and this is their decision and they have taken into account all relevant factors. This is not satisfactory. And then concerning Mr. Justice Falk, can you give us more information? Now, in fact, permanent judges were appointed before. Can you tell us more about their seniority, their years of service, in the Court of Appeal, for example? But every time you are telling us that JOC has considered the matter very carefully, JOC has had a thorough discussion, and this is the best candidate, this is the best appointee. So I'm not asking you to disclose very sensitive information, but can you try to help LegCo and the public know more about the situation? Is there any unusual about this appointment? Is the years of service of this judge particularly short? And if the answer is yes, then is there a reason for that? But we don't have such information. We simply don't know. So how can there be a meaningful dialogue between us? Ms. Lau. Now, every time the JOC considers the matter very carefully based on the merits of individual cases. And concerning the length of service of the appointees, this varies. If I remember correctly, one judge had not joined the judiciary for a long time before he was appointed as a permanent judge of the CFA. So please give us a table. Not too many permanent judges have been appointed since 1997. So we want to know their seniority, their years of service in the judiciary before they were appointed to be permanent judges. So can you try to give us more information? Can you disclose more information to help us understand why certain judges should be appointed? Please don't just tell us that the matter has been given thorough consideration and these are the best candidates or that these are the best appointees. Yes, Chairman, thank you. Now, in fact, there is a set of procedures for making judicial appointments under Article 73(7) of the Basic Law. In the past, members asked for more information about the appointed judges, their judicial experience, their publications, their judgments, and the judiciary did provide the information to members. Now, we do agree that we need to assist LegCo in its discharging of its duties under Article 73(7) of the Basic Law. So we are willing to try our best to assist. We are willing to provide as much information to LegCo members as possible concerning information about the judges. So is it that you can give us more information this time? Members have asked for information about the judges. The JA will try to provide such information. Yes, Mr. Paul Chair. Yes, thank you. I have 3 groups of questions. Now, concerning Mr. Justice Fox's case, it's a bit special because the people get the feeling that he is a high flyer, so to speak. And we are told in the CV that he did practice, though on a part-time basis, in Singapore. So he was not in legal practice in Hong Kong for a very long period of time. So some members would like to know whether there weren't more suitable candidates among JAs in the Court of Appeal. Now, I think some people say that concerning the appointment of SCs and the appointment of judges, things will be smooth if you know certain people in the sector. But of course, this is mere speculation. But then some people do have this impression. Now, in the past, nobody really queried the recommendation of the JOC, but now we know that things are getting more sensitive because many cases which go to the CFA do have a political flavor. So, we're not saying that we should adopt the U.S. system, in other words, appointment by the president and endorsement by the Senate. Still, we need to do more in Hong Kong. So I think the administration should give us more information concerning Mr. Justice Fox's case. Do you have difficulties? Is it that there are no other choices, or is it that some were offered the job but they declined the offer?
Just now, Mr. Liu also asked a question about the two overseas justices. One is from New South Wales, one is from the Australian High Court. I think they are experienced enough. But then now the role of CFA is more political in nature. So would it be the case that all of a sudden we have many Australian judges? Usually, they are more avant-garde in pushing forth legal reform. And when compared, the British judges are more conservative. So if all of a sudden CFA becomes too proactive, or they are too avant-garde, then will this be an issue? I have been victimized, so to speak, as Mr. Leung Kok Hong. If a CFA judge has strong political orientation, then his judgment may affect the direction of the whole court. As Mr. Liu Chang-kong said, we're talking about very senior, high-level international judges. So when the Chief Justice appoints non-permanent judges from other common law jurisdictions, I think there will be some directional influence. My third point is, when you refer to the annex on the background of Justice Gamo, well, his father passed away as a member of the Navy. Now, is this a special reason, or is there a special reason to highlight this point? Justice Fox's mother used to be the deputy chairman of a revolutionary society in Hong Kong in the past. So is this a factor a relevant factor of consideration? Thank you. Ms. Lau, let me respond. I would like to emphasize here that the work and mission of the judiciary is to hear cases according to laws, so there should not be any political consideration. When judges hear cases, they act in accordance with the laws. When JOC recommends judges' appointment, they will also do so according to the basic law. They will refer to the competence and judicial background or legal background of the judges. Other personal factors will not be considered. I would like to now respond to Mr. Zhe's questions. The first question is about Justice Falk. I explained about his appointment just now. Members asked for more information on, for example, cases heard by him in the judiciary and comparing with other permanent judges of the CFA. What is his year of service like? As I said just now, George has gone through a very detailed process from a long name list to a short name list before deciding that Justice Falk is an appropriate person. Later on, I will provide more supplementary information. I hope that Mr. Zhe will have more understanding of Justice Falk's work. In relation to non-permanent judges, now we are going to have 2 Australian judges, but if you refer to non-permanent judges from other common law jurisdictions, apart from Australian judges, there are English judges and New Zealand judges. When they are appropriate and when they are willing to take up the positions, well, they are all very excellent position holders. They have been appointed and they accepted the appointments. There is no other consideration. The basic law states that the people's competence and judicial experience will be the only factors to be considered. As regards Justice Gummo's CV, well, it's provided by him. Justice Falk's CV is also provided by him. As regards what information is included, well, we respect their personal opinion. Mr. Paul Zhe asked a question on whether there are too many Australian judges. Can you elaborate? We're talking about MPJs. Thank you, Chairman. There is no question whether there are too many or too few. If there are appropriate persons from these 3 common law jurisdictions, namely Britain, Australia, and New Zealand, then these suitable people will be suggested for consideration. Now, this time, these 2 NPJs are from Australia, but not all are from Australia. Well, with these 2 judges, can we have a list of the nationality of all the NPJs? Is that okay? Yes. Mr. Leung Kwok Hong. The judges and legal practitioners said that justice has to be seen to be done. Well, when judges are appointed, does this principle apply? If LegCo members find a certain appointment unusual because of perhaps ignorance, then if we respect ourselves, then I think we should make sure that justice can be done and can be seen to be done. I think in order to be respected by others, we have to have those qualities. If you consider the appointment of judges based on age, this doesn't start from today. That started from Justice Lee Kwok Nung. He said that he was too old. He wanted CFA to be younger, so those who are of similar age should not stay in CFA. Now we have Justice Ma, and then Justice Ma is trying to promote another so-called genius. I did not study law, but then I think if things happen repeatedly, but if that thing is not explainable, then this is a paradigm shift. Is it true that one of the necessary conditions is age? if we want justice to be done. If so, it should be written down. Justice Ma is of similar age as I am. Today we are not doing too much. We are asking about several principles. I understand Ms. Margaret Ng's worry. If the legislature can intervene or interfere with appointment in the judiciary, then of course the political party with majority of seats can interfere or can have majority of seats in the judiciary. But then if there is no criterion at all, let's say this time we're talking about age. Is age a factor? This should be double thought. If we talk about Justice Fogg, well, he's the one arousing a lot of controversy about Macau-Hong Kong Zhuhai Bridge. So I did not consider this factor. But if our colleagues are saying that he had only handled very few cases, but he is now being recommended. So this is really a big doubt. Perhaps he has achieved a lot. He has written a lot of articles. Or is young age more important? Or is it true that Justice Fogg has achieved a lot at the same time he is young and he has many publications? Then of course he is an excellent choice. There should be a horizontal comparison. Mr. Fogg is a high flyer. How many such high flyers are there? If we do a vertical comparison, well, that is done already, but is there a horizontal comparison? Are there such geniuses in other common law jurisdictions? If we cannot get that intersection of lines in other countries, then there are problems. There are questions. Please don't misunderstand that we imply that there is favoritism, but then the criteria are not clear. I think this study must be done. Let me repeat. I have almost no confidence in Hong Kong judges. In the future, I have to face them. I know that it is not beneficial to me when I say that. But then if you adopt a scientific method, you have to consider this point. When Porter asked you, why is it that the judges are rather old age, and you said that there's a shortage of manpower in Australia and New Zealand, and so they can only come after they've retired. Why is it that all of a sudden Hong Kong has become a world of genius? Justice Patrick Chan has heard so many cases. Why isn't he a permanent judge? But then the age factor is mentioned. Then why is that possible for NPJs? This is still a question mark. For NPJs, NPJs can be 71 years old, but then for permanent judges in Hong Kong, only 65 years is the age limit. Is it because we have too many people? We have very exceptional circumstances. We used to be a common law jurisdiction, and now we have constitution. CFA hears cases based on the constitution. My case is an example. The judges are not really familiar with using basic law. They, of course, their remarks are valid in the UK. So I am really aggrieved. We are talking about very poor judges. Yes, this is exclusive case, but then I think the standard is really low. So is our decision based on age or experience? It seems that the principle is moving all the time. Justice Patrick Chan is okay. Is he ill? No, right? I know. Why is age a factor? In Australia and New Zealand, perhaps their experience is an important supplement. So even though they are rather senior in age, they are still being recommended. But you haven't really explained the principle. Ms. Lau? Thank you, Chairman. I would like to respond to several points regarding MPJs. In the Court of Final Appeal ordinance, we have permanent judges. At the same time, we have MPJs. Usually, MPJs are retired judges. They are not full-time judges. They are part-time judges. This is the special arrangement in the CFA ordinance.
The member asked whether age was a consideration. Now, I can make a few points. Now, because, of course, when an appointment is recommended and made, we have to make sure that the provisions in the law are complied with. And when a judge reaches retirement age, he usually vacates his judicial position. Mr. Justice Chan is approaching retirement age, so he will be vacating his judicial post, but then we are recommending that he should serve as a non-permanent Hong Kong judge of the CFA. Now I want to say that under the law, we have to choose the best person for the job. Age is not the most important factor. Now, Mr. Justice Falk is a relatively young appointee. And in fact, Jock did recommend a very experienced judge, Mr. Justice Tang Ching, to be a permanent judge. So in fact, the Jock attaches great importance to the professional and judicial qualities of the judges concerned. So, concerning the judicial experience of the judges, the judgments they have handed down, this is open information. We can easily provide such information to members. And as far as I can remember, for the Honorable Mr. Justice Ribeiro, he was when he was appointed, he had not been serving in the judiciary for a very, very long period of time. Mr. Leung Kwok Hong. Now, I think my methodology is different from yours. I can do my own research. If you are saying that there are two main factors you consider, then you can consider whether based on these two factors, Mr. Justice Falk is the best person for the job. I think the legislature cannot really monitor the judiciary. I think the mass media can, but of course I think the mass media really haven't invested in this area to monitor the performance of the judges, that is. Ms. Priscilla Leung. Now, the system we have in Hong Kong in making judicial appointments is different from the system in the U.S. So in some states in the U.S., judges are elected. They have their political stances, and they have to secure enough votes before they can be judges. So their system is very different from ours. Now, in fact, justices of Supreme Courts or High Courts around the world have to deal with cases of political nature. For example, in the U.S., the judges have to deal with cases concerning election of the president. But most of these judges have to handle cases of overriding public interest. So these are cases related to public interest. For example, in some countries, the Court of Final Appeal has to come to a position on, say, the country's population policy. CFA judges are, of course, very important in society. Now, concerning the two non-permanent common law judges, of course, they extremely experienced. They are of eminent standing and reputation. But then there are many common law jurisdictions in the world. Why is it that we have chosen these two judges? I'm not querying their qualifications, not at all. But why are we choosing these two judges? Now, I can remember that in 1999, there was the right of a bold case, and one of the non-permanent common law judges asked what MTR meant. That was because in the court there were arguments put forward about a very great increase in population. If people were given the ROA, so of course the CFA deals with a lot of very important cases which affect public interest. So can I ask why these two judges have been recommended for appointment and not the others? What are the criteria? So I want to know about the criteria. Now, say for our universities, when the vice chancellor or when senior professors are appointed, there is worldwide or global recruitment, and then there's a due diligence process. The process may not be made open, but within the selection committee, there is a due diligence process. Now, on one occasion, someone was appointed, and it was or recommended for appointment, and it was discovered that in fact he had a record of discrimination against others in another country. As I have said, in LegCo, we understand that when it comes to the operation of the judiciary, we should exercise restraint. We do not want to interfere. But then, of course, we do receive some complaints about the acts of the judiciary. So I just want to know more about the criteria. The criteria for selecting certain judges, the criteria for recommending certain judges for appointment. Now today we have this letter from this member of the public. Maybe there are other members of the public who have the same doubts or discontent. Yes, in Hong Kong we also practice the common law. But Hong Kong is unique. We have the basic law, and in the past 15 years, there were cases tried, and the basic law dimension was used. And non-permanent common law judges may not know Hong Kong too well. So I want to know about the criteria for recommending these judges. I'm concerned about transparency and whether we do have consistent criteria. Yes, Ms. Lau. Now, concerning the appointment of judges, the process of appointing judges, it must not be politicized. And I'm glad that Ms. Leung is of the view that the U.S. system is not suitable for Hong Kong. The AG Ellis panel has discussed the procedure to be adopted by LegCo, and that's why we have this present set of procedures. Now, the JOC acts in accordance with Article 92 of the Basic Law, and in fact, judges are appointed based on their judicial experience and qualities. Now, let me say something about the CFA. Now, very often when cases go to the CFA, legal points and perspectives are argued. So judges have to deal with disputes on legal points. And judges have to hear the submissions of the lawyers. And with regard to the participation of non-permanent common law judges, I think we need to note a few points. First, now when they sit in the CFA, they sit as Hong Kong judges. They have to take the oaths of Hong Kong judicial officers. Secondly, when they sit at the CFA, they mainly deal with legal points. Now, if they need to know about the Hong Kong situation before they can do their work effectively, there will be sufficient such information made available for the reference of these judges. And also, the judgment of the judges is open information. So concerning Hong Kong judges and also the these two Australian judges, you can find their judgments very easily. And so the professionalism of these judges is known and easily known to all in the legal sector. The Hong Kong CFA was established in 1997. And since then, CFA judgments have been uploaded onto our website. And in fact, judges from in other common law jurisdictions do make reference to judgments handed down by the HKCFA. So there is some good communication in this regard. So I want to say again that the criteria for appointing non-permanent common law judges are clear. Ms. Leung is saying that some members of the public may not know that if they have complaints against the judiciary, against judges, they should write to the judiciary and not to LegCo members. In fact, we've also uploaded onto our website the procedures for complaining against the acts of judges. And we have also prepared pamphlets which are available at the judiciary. And if LegCo members do receive such complaints, they can refer them to the judiciary. Ms. Leung, I wish to follow up further. In fact, we've referred some cases or complaints to you, but then the complainants are still unhappy. They want further information. Now, I will not be talking about individual cases today. But we really do want you to perfect your complaint handling mechanism. In the past, few people would ever think of complaining against judges or the judiciary. But now, people expect the operation of the public sector to be transparent. And so, if they find your replies unsatisfactory, they will come back to us for help. But of course, we hope that you can deal with such complaints in a satisfactory manner so that we will not have to handle them. Now, for example, there may be complaints against universities, and LegCo really doesn't want to interfere. It would be good if the universities can resolve the problems themselves. So can you progress with the times? Can you perfect your complaint handling mechanism so that the mechanism and the way you handle complaints will be easily understood and accepted by members of the public?
Ms. Lau, thank you, Chairman. We will make sure that we will pay attention to room for improvement in accordance with changes of time. Sometimes members of the public wrote to us that they are not happy with the results of the trial. If they are not happy with the judgment, then this should not be dealt with via the complaints mechanism, because this is an intervention of judiciary independence. So they have to take the judicial or legal route. We have tried to explain things very clearly to the public. We hope that things are acceptable to them. But of course, whether they find things acceptable is not up to us to decide. We will try our best to explain more clearly. If there are complaints about the behavior of the judges instead of the judgment, there is an established process to handle the situation. We will definitely send written response or replies to the complainant. Of course, we will continue to pay attention to what Ms. Leung referred to. Next, Ms. Sitho, but she is not around. So let me turn to another issue. Para 16 of the LegCo paper. Ms. Margaret Ng and Ms. Emily Lau asked whether or not the Secretary for Justice should be a member of JOG, because the Secretary for Justice is a politically appointed official. If we don't want to politicize judges' appointment, then should we allow the Secretary for Justice to be a member of JOG? As we all know, recently the Secretary for Justice is involved in a very important constitutional case, and the Secretary for Justice asked CFA to request interpretation of the law. I want to know whether there is any new thoughts of the administration. Thank you, Chairman. I can respond on behalf of the administration. Chairman, as you know, this issue is not only raised here, it is also discussed in the AJLS panel. There has been in-depth discussion. In 2011, there was a paper on this point. And today, in para 16 to 18 of the LegCo of the background brief prepared by the Secretariat, the administration wants to say that Secretary for Justice has a constitutional function to safeguard public interests and defend rule of law. The Secretary for Justice is the chief advisor of the CE on legal matters, and he is also a user of the courts. So Secretary for Justice has a very unique status. He has very rich legal professional knowledge. So now the Secretary for Justice is one of the 9 members of JOG. We don't see any problem with this because he is a user of the court. He is the Secretary for Justice of the SARG. So he should be able to make contribution to JOG. Today, I'm happy that many members said that judicial appointments should not be politicized. Even Mr. Leung Kwok Hong made that point. So I agree with the I agree with Ms. Emma Lau. If things are politicized, then there will be a lot of impact. And there is security of tenure of the judges. So you don't need to worry that the tenure or the judges will be impeached or will be dismissed because of any political consideration. So the Secretary for Justice, as one of the 9 members of JOG, is fully acceptable. This is not problematic. Any other questions? Mr. Liu Chang-on. Thank you, Chairman. I have heard so many government remarks today. I just want to make a point. There is not a need for a response. I only make my point once. I won't repeat it. The mainstream view today is that in the future, there should be more transparency in making judicial appointments. And there is a public request here. And I think this is a reasonable request. It should be responded to in a reasonable manner. In the future, concerning judicial appointments, we are asking for more transparency, but we should not say that this is politicizing the judiciary. If the judiciary is to be politicized, I think many members will object to that. So I hope the administration can enhance transparency in making judicial appointments instead of politicizing things. As the director said, judges' tenure is whole life. So there is little chance of politicizing appointments. So that is exactly why there should be more transparency, because after a judge is appointed, it's not reversible. So I hope that you can listen to public requests and take on board public requests. Mend them or end them. This is an English saying. If you don't change to respond to people's requests, then in the future there will be people who will help you to change. Thank you. I think Mr. Liu's conclusion reflects the view of this subcommittee. We hope that the recommendation process is open, transparent, and objective. If the administration can provide more information so that this subcommittee can understand the procedure more clearly, then, well, I think this is really necessary. Other members have asked some questions. The administration said that more information will be provided for us to consider this matter. So after receiving your paper, I will distribute the papers to members. I will then ask whether there's the need for another meeting. Mr. Liu Chang-kong said that there's not the need, but other members are not here. So can we do it this way? Okay, if there is not the need, then we can report to HC. If there is the need for another meeting, if some other colleagues would like to ask more questions, then we will have to meet again. Okay? If there is nothing else, then we can adjourn here.